Let's see what happens today.
Numbers 1 and 2, People versus Richard Allen Bass, 2244 FC, 22239 FH.
Jessica Blanche on the FH case.
Good afternoon, Your Honor. Amy Reiser appearing on the 2244 FC matter, sexual assault.
Good afternoon, Your Honor. Jake Kilowog, Your Honor, 22044. The assistant public defender on the case, Your Honor.
Okay.
Richard, can you state your name, Your Richard, can you hear us? Raise your hand if you can hear us, Richard.
There we go. Can you hear us, Mr. Allen Bass?
I can hear you.
Okay. We're here today. We were here last week. There were a bunch of motions filed, and I think I told you that, we weren't going to proceed because you have a lawyer. I understand your position on this, but your lawyer did actually file a motion, so I'm going to take that matter up first. So Mr. Kilowald filed on your behalf a motion for a new trial or a directed verdict. I have had a chance to review that. I'm happy to hear if you want to highlight any arguments, Mr. Kilowald, you may.
Just real quick, Your Honor. I'll let my motion speak for itself. The only thing I wanted to get to was, again, the reason for the request for a new trial / directed verdict would be Section D, that I don't believe, Your Honor, there was sufficient evidence to support conviction. I understand, Your Honor, you also heard the witness testify on young little victim. Again, Your Honor, I don't think her testimony, and again, I'm not trying to say she was not truthful, Your Honor, but I'm saying she's a very confused little girl who, for the first 15 or 20 minutes, just sat frozen on the witness stand because of all the jurors watching. That being said, Your Honor, I think there were numerous inconsistencies in her testimony, Your Honor, that I think Your Honor should recognize that based on that, Your Honor, I don't believe the jury should have come to the verdict it did. And I'm asking you for a new trial in this matter. I'm also saying, Your Honor, and I hate saying this because I like you as a judge, I like my client, but there was obviously friction between you and my client. I know my client left some Zoom hearings with offhanded remarks. And Your Honor, my client believes that you could not be a fair judge in whether through the trial or sentencing, Your Honor. And based on that, Your Honor, I'm asking you to grant my client either a directed verdict or a new trial. And I'll let my motion speak, the rest of the motion speak for itself.
All right. Ms. Reiser, I have had a chance to review your response. You're welcome to highlight anything you wish, and we'll proceed.
Just briefly on what I've stated in the motion, in reviewing a motion for a new trial on the ground that the verdict was against the great weight of the evidence, of course, must review the whole body of the proofs, but may not sit as a 13th juror so as to grant the motion based on a disagreement with the credibility determination made by the jury. Not to say that Your Honor would disagree with the jury's verdict here, but that's what Mr. Bass and Mr. Kilowald are asking you to do. And that would be inappropriate in this case, and that's People versus Lemon 456 Mish 1998. Conflicting testimony, even when impeached to some extent, is an insufficient ground for granting a new trial. So I think I would rely on the law that I've stated in my response, that the jury in a criminal sexual conduct first case can convict based on the word of the victim alone. And there was certainly other evidence in this case, but the jury was instructed. Jaleila's testimony was clear. It provided a basis for the conviction, and it described the cunnilingus. She identified the defendant. She was under age 13 at the time. He was over age 17. So, and it was a fair trial. The motion that was filed by Mr. Kilowald requesting a new trial just sort of kind of lays out a bunch of unsupported claims, nothing that's supported in the record. The trial was fair. There was an impartial jury selected. And so for the reasons stated in my motion, and when you view the light most favorable to the prosecution, we would ask that you deny our motion.
Okay. Matter is before the court on defendant's motion for a new trial directed verdict. Defendant argues he's entitled to a new trial due to insufficiency of evidence and conflict of interest with the judge. First, as a matter of procedure, the motion is untimely. MCR 6.431A1 states that a motion for a new trial must be filed within 42 days of entry of judgment of sentence, which would be today's date. However, the court will consider the motions on the merit. As to the sufficiency of evidence, there was sufficient evidence upon which a jury could have convicted Mr. Alan Bass, and that was the victim's testimony, which under the law is sufficient evidentiary basis for a conviction. The jury was instructed on how to access credibility before and after the proofs were placed on the record. As a matter of fact, during voir dire, I think every juror recognized and acknowledged that occasionally children lie. However, those 12 people hear all the evidence and believed the defendant or believed the victim, which is their role. Identity and credibility were the basis of the defendant's theory to raise reasonable doubt, but a jury disagreed. As to judicial conflict of interest, any court of law in the state of Michigan has inherent authority to punish contempt, whether direct or indirect. On June 27th, 2022, this court heard a bond argument which was denied. At that hearing, the defendant stated, quote, "Y'all on some straight bullshit, I swear to God, bro," and then said, quote, "Suck my dick, fuck you, bitch ass." He then got up and walked away from the Zoom hearing. On August 1st, 2022, at the next court hearing, the defendant was found in contempt, and I took his sentence under advisement pending resolution of the trial. At which point the defendant stated he wasn't talking to me, and even if he was, he had, quote, "freedom of speech." Mr. Alan Bass, what is said in court and before the judge does matter, but it doesn't necessarily make me prejudicial or prejudiced toward you. You're not the first person to say vulgar things to me. You're not the first person to insult me. And candidly, at this point, the reason I didn't sentence you for contempt was because I wanted the process to play out with 12 jurors who heard evidence and rendered a verdict. So there is nothing personal between us, sir. I took the contempt proceeding under advisement for the purpose of sentencing you. The First Amendment is not a shield to use in the case of clear, unambiguous contempt, and a court acting consistent with authority is not a basis for a new trial. Again, 12 jurors decided your guilt, not me. The jury never even heard about the previous contemptuous behavior. So your motion for a new trial or directed verdict filed through Mr. Killewald is denied. So, sir, the question is, are we prepared to go to sentence today or no?
I want to get their hearing on the record. That's all I'm asking for.
Okay, so I'm going to adjourn the sentencing in this matter to April 26th, and I'm going to require that you be here in person, and we will take up these matters then.
I want to get their hearing on the record. I will not be there.
And I'm not available on the 26th.
Okay, well,
Richard,
what's the next week?
Could we do it
The
this week?
19th.
I'm not gonna be here.
Can't do it the next week, but we could do it the following week.
How about May 3rd?
May 3rd?
I wish it were tonight, Your Honor, but that's fine.
I plan to be here on May 3rd, so let's do it then. We don't need to inconvenience you two in any way.
It's fine. May 3rd to be fine. Does my client be in court?
He will be in court, yes.
I don't want to prejudice someone more, but I think he may have to.
It's not an option at this point because he will be sentenced at that time. Sure. Okay, we are back on the record in People versus Richard Allen Bass, two files. One is 22-44FC, the other is 22-239FC. This is the date and time set for sentencing of the matter. I will note that there was a bench conference with both the prosecutor and defense attorney. There was obviously robust discussion between the court and the defendant as well. The defendant has left the hearing, and so there's nothing I can do about that. However, after discussing this at the bench with counsel and some concern about delays, I am going to adjourn the sentencing on both files until tomorrow at 11:30 a.m., which would be April 13th at 11:30 a.m. And I am ordering the defendant be brought down in person for the sentencing, and I will contact transport and make sure that that happens.
Thank you.
Okay?
Do you want Mr. Killewell to prepare an order denying the motion for new trial?
I do, yes. Well, did you want Ms. Reiser to prepare that motion? Of course you're ready to do that, Mr. Kilwall. I know.
Last one.